Under California law, under California Fair Employment and Housing Act, qualifying employers who employ 5 or more employees have an obligation to provide reasonable accommodations to those employees who have a qualifying disability or a medical condition within the meaning of Fair Employment and Housing Act. There is no set list of accommodations that are considered reasonable because the law encourages both employees and employers to be creative when looking for a solution for a disabled employee and when looking for an accommodation that's both reasonable and effective that would allow that employee to continue performing his job duties with or without restrictions. Many people ask, well, what is reasonable? How are we supposed to know what is reasonable accommodation and what's not reasonable? Well, that's a good question. The term reasonable is obviously very vague and very relative. And that's why so many claims out there and so many disputes and lawsuits revolve around trying to interpret what's reasonable and what's not reasonable in each situation. Employees naturally urge the courts and the agencies to give a broader interpretation to what's reasonable, while the employers want that term to be interpreted more narrow. We're not going to be able to identify what reasonable accommodation is today because it's impossible. Every situation is different. What's reasonable in one case might not be reasonable in another. It so much depends on an employee's job duties, on his work hours, on the type of organization he works for and the size of that organization, the number of employees they have, their financial resources, and other factors. So there is no set recipe for determining what's reasonable and what's not. However, there are a few important principles that do not change. There are a few core principles that both employees and employers need to be aware of and need to keep in mind when they try to figure out what's reasonable and what's not and what their respective rights and obligations are. First, reasonable is not the same as perfect. An employer has the obligation to provide a reasonable accommodation. Employers do not have to provide a perfect accommodation. Here's an example. Let's say you have a teacher at a high school who witnesses a really bad, violent incident in class. Maybe he observed it, maybe he was himself assaulted by one or more students. He goes out on leave and then he comes back, but he still suffers from psychological symptoms. Maybe he was diagnosed with PTSD, with post-traumatic stress disorder. He makes the following accommodation request. I want a full-time security guard to be at all times in my classroom to ensure my safety and to ensure that this doesn't happen again. Well, the law is pretty clear that asking for that much, asking your employer to hire an extra person, especially an extra full-time person, is not a reasonable accommodation in most cases. Maybe there are other accommodations. Maybe that teacher can be transferred to another class. Maybe there are some other solutions to this problem, but generally you cannot expect your employer to hire an extra person. That would be a perfect accommodation, but most courts and most agencies will agree that that's not reasonable. That's beyond reasonable. Second important fundamental point. Reasonable accommodation does not mean the accommodation that you, the employee, is asking for. An employer has the right to reject the accommodation that you're asking for and suggest another, maybe equally effective accommodation. For example, let's say you've been diagnosed with a severe back or neck problem and you need an ergonomic chair. You go out there and you find an amazing high-end chair for $10,000. You come to your employer and you say, I want the following accommodation. I want that chair near my desk. The employer looks at the chair, they're thinking it's a little too expensive. They invite their own ergonomic specialist who evaluates your desk and they find a different chair. A chair for $2,000 that appears to be equally effective at accommodating your condition. The employer is not obligated to buy the chair that you're asking for. They can perfectly, lawfully buy the chair that works just as well for you and addresses your limitations, addresses your pain, your injury, your disability with a chair that they choose. Third point, and this is mostly for employers to know so that they don't make the mistake that leads to claims and lawsuits. If your employee is asking for an accommodation that you cannot provide, but you know that you can provide a different accommodation, you're much better off not saying, no, we cannot give this to you, but instead saying, we cannot give this to you, but we can give you something else that should accommodate you just as well, or almost as well. Example, you have an employee who has a hard time walking and getting to work. That employee is asking you for the following accommodation. I want to work from home 100% of the time, 5 days out of the week. If you're unable to make that accommodation, but you know that you can provide partial telecommute as an accommodation, then just say that to your employee. We cannot give you 100% telecommute, but we can allow you to telecommute and work from home 2 days out of the week, or 3 days out of the week, or maybe we can allow you to commute 100% of the time, to telecommute rather 100% of the time during that season when it's not busy, but we cannot do this for you when it's really busy. We need you in the office. Don't just say no, because no often leads to liability if you have other options, if you can provide other accommodations. Say no if you mean it, if you really cannot do something that the employee is asking for as an accommodation, and suggest 1, 2, or as many alternatives as you can. Do not stop the dialogue. Do not stop the quote-unquote interactive process. And the last point I want to make is the point about undue hardship. The law says that employers, qualifying employers, have to provide a reasonable accommodation unless providing that accommodation would impose an undue hardship. The important point to remember, especially for employers, is that the employers have the burden of proving that a particular request imposes undue hardship. And of course, the bigger the employer is, the more money they make, the more employees they have, the more difficult it would be for the employer to argue that we couldn't provide this accommodation because it was an undue hardship for us. Undue hardship is not just empty words. It's hardship that's undue. It's not just a challenge, because providing any accommodation is a challenge, is an extra work, an extra effort for the employer. It has to be a big burden, an undue burden. So here's an example. If there is a nurse that needs to take time off work because she has been injured and she works at a small clinic and she needs to be out for a year, that might be an undue hardship on a small operation when there's only a few nurses. However, if that nurse works for a major hospital, I don't know, for Kaiser, for Sutter, and there is 100 other nurses who do exactly the same thing, then the hospital will very likely have to provide that accommodation of allowing her to be a year off because of her medical condition, or even longer than a year. Again, there's no set amount of time that the employer has to provide in terms of medical leave as an accommodation, but the larger the employer is, the harder it will be for them to argue that providing medical leave or any other type of accommodation was an undue hardship. Thank you.